I have 9 questions, which I'll tackle very first. What I have done is I have classified it into topics because they were across the board. The first is the relevance of rejected votes in the counts of the election. This is a matter that we have asked the court both in 2013 and 2017 to relook. We wish to resubmit as we resubmitted the 2 times, and to say that it is still our position that people who come out to vote, whether their vote is counted or not, are coming out to make a stand on the issue, and whether either due to technicality or other reason their vote is not counted, they must be not treated as those who stayed at home. They are people who came to express an opinion on how they want to be led, but for various reasons their vote was not counted. But the fact that they appeared should be taken into account, so that you would consider their votes whether they are rejected, and even if they are called stray ballots, should also be considered in that sum. The second question was regarding the scientific whether there are any scientific studies regarding the nexus of elections in a postponement. We have seen, unfortunately, we could not tender any further documents of this, but there are very many theories in political science, one of which we came across with the contagion theory, that elections affect each other. People come out to vote for various reasons, and especially when you're dealing with elections of a national level and a devolved level, there are very many considerations that would make somebody want to come to make a decision on a devolved government or a national government and not necessarily care about the other. But one of the things that we also must consider in Kenya's political culture is that in Kenya we do have 6-piece kind of campaigns, and that people come out to campaign together as teams, trying to win across the board on all the seats. And that when you disenfranchise one, when you stop one election, that means you demobilize part of the political infrastructure that is laid out for that. And lastly, on this point, we want the court also to consider that, at least in respect of Mombasa, and our evidence has shown that there was an order from the Mombasa High Court that has stopped the printing of these ballots, and that was disobeyed. There was also a promise that had been made by the chairman that he will not print, and he went against that too. And lastly, that it was announced on the last minute in that night. The third issue was what elements of Section 80 of the Elections Act we consider necessary in the face of the fact that we are also impeached the process. Apart from the elements that are laid out themselves in Section 80, which is that upon a recount, the person should have been a winner, and that the person should be found not to have committed any electoral offense. In our submission, we wish to add that first, the test should be whether the petitioner is culpable for any of the wrongdoings that is complained of. Secondly, whether the petitioner benefited from any of the wrongdoings that are complained of. And thirdly, that after, whether it is a recount or a retally, the petitioner appears to have won the elections or has won the election. Those would be the tests that we would add to what is stated in Section 80. In respect of the question of image on the KIMS, the evidence that has been shown also even from the Commission is that the images are taken on a JPEG format, and the idea of the law of electronic transmission was that that image must appear as it is on the other end. The issue here is that there appears to be a place at which that format was changed. No reason has been given why that format was changed, so that it can go to any other format. But also to add that through one of the most popular applications today in Kenya is WhatsApp, and nobody changes. We get a lot of images as original as they are, as colored as they are, in the hundreds on an everyday basis. And I do not think there is any justification why an image taken on a JPEG on a KIMS-kit cannot appear in the same format throughout the electoral process. The other question was in respect of the evidence, whether the 4 commissioners participated and what that meant. I would ask the court to look at the annexures that are put as MWK3 in the affidavit of the second petitioner, Martha Karua. And in that flash disk, there are 2 incidences at the National Tallying Center. In one incident, Commissioner Justice Nyangaya comes out to read the results of Kiambu Town constituency. After he reads the results, it turns out that the result he has read has overstated the votes of William Ruto by 10,000, and also that he has gone past 100% of the votes cast, and he is forced to have to come to reread the results. That shows the commissioner had not known what he was reading. The other video is that also of Juniera Cherele. Again, she is given results to read of Juja constituency with the same results, inflated votes for the respondent, and a more than 100% voter turnout. And again, the results have to be reread. That would leave it to the commissioners themselves to explain. The other issue is about the constitutionality of Regulation 87. Now, first, our position is that a regulation or any act that is unconstitutional does not need the order of the court to be nullified. It is already nullified by Article 2. And at any time, it remains a nullity ab initio. The second issue to consider is the duty of every person, not just the court, to defend the Constitution as required by Article 3. And the fact that this chairman, the chairman of the IEBC, is a person who has qualifications similar to be the Supreme Court judge. So it is him who has betrayed the Constitution. It is him who has seen a regulation which is so clearly unconstitutional, has refused to defend the Constitution, and instead feigned ignorance and purported to use an unconstitutional provision to exercise power. So on that basis, every action that is done on the basis of that regulation is itself unconstitutional. The other question was regarding why the 4 commissioners did not raise issues to the end. Again, that we will leave for the commissioners to decide, but we can profile 3 theories. One is the issue of the 89th minute penalty, that if you participate in a game and the wrong penalty is given on the 89th minute, you cannot be asked, why did you play all along? Sometimes it is the 89th minute penalty that shows the unfairness of the provision. It could be the last straw that broke the camel's back, or it could be a road to Damascus moment. In whichever fashion we look at this, it is an issue that is understandable. The other question is in regarding for if there were to be ordered a repeat election, who would conduct it? Would go back to Article 250, Sub-Article 10, because the Constitution provides for positions of vice chairpersons of all commissions. But Article 250 does not lay out any roles that they're supposed to be undertaken by those vice chairpersons. Our position is that that provision is not empty, and it is meant to provide for succession plans in commissions in places where an emergency or situations such as this, where such a succession is necessary. But the second issue would also be that the court itself, in inherent powers, has the power to ensure that its orders are fully obeyed and fully executed. And in such a situation, the court would treat its order as an order that has to be executed and would have the inherent powers to make all such other orders that are necessary to ensure that those orders are executed in full. Before I go to my last issue, I want to comment on something that was said about no agents. And one of the issues this court was told is that it appears there's a jurisprudence that is being built that where an agent does not appear from the other side, then the opposing side has a right to steal or a right to commit fraud, or somehow excuses the IEBC from any duties because there was no agent. And in fact, one of the advocates likened, said that you must have agents in every place, and even likened to agents. I said they should be like your wife. I believe that is what was said. Apart from the fact that that statement is very sexist and insulting, not just to women, but even to constitutionalism. Their courts must restate the duty of IEBC to protect the vote at all times in every place, and that it cannot pass the buck to parties when wrongs happen, and also must put the obligation on every contestant in an election that if you meet a place where there is no agent, it does not give you a right to steal the election in that place. The last issue, and I follow this up with what my learned friend Maha did, I want to show the courts a Form 34A from a place called Gasharaigo Primary School, and it is in Muranga, in Kangema constituency, in a ward called Murugo, in stream 2 of 2. And this document is overlaid over some documents, but look at the left-hand top corner. It is overlaid over a document written Jose Camargo. Jose Camargo is one of the Venezuelans that was arrested at the airport with charges of coming to interfere with the elections. He is one of the people that the last Mahat has said did not have access to the RTS. This form is in the official portal of IEBC. The question would be, was this document photographed by a presiding officer at Gasharaigo Primary School, sometimes possibly at 8 o'clock in the night? Or is it possible that this document has been photographed elsewhere in some office and uploaded? This, we ask the court to read the DCI report regarding Jose Camargo, and we believe, my lords, that these are the fingerprints of one of the suspects of the theft of this election. That is all.